them to take in relation to remuneration. So one of the responsibilities really as a trustee or as a trust officer, when you take on a new trust and you're reviewing your documents, make sure that there is a fee charging clause in your deed. Other than that, you work for free. Or you have to go to court. There is a rule in equity that indicates that a trustee should not purchase trust property. Why?
Because it could be seen as a conflict of interest.
Conflict of interest?
That the trustee is benefiting from the trust.
Or his position as trustee. Not beneficial from
Right,
trust,
but
his
it's-
position as trustee, because he has the information. And you find that sometimes, especially if you were to do an estate, let's say if somebody has done a will and the person dies, he might have like a coin collection, or he might have a collection of jewelry, or he might have a collection of books, or something of that nature. And you decide that, well, I like that coin collection that he has. Is, the minted thing is when Bahamas went independence invented in 1973. They issued some gold coins. They're valuable now. Let me purchase those. And so you go and you purchase the coins, and the beneficiary will come back later and say, well, you have knowledge of the value of the coins, and so they want to undo the transaction. It may be the same thing when it comes to real property. For instance, there might be, someone might have discovered that the property sits on an oil field, and because you haven't explored it yet, you don't know that it's there, but the trustee has knowledge that there's a possibility that oil might be there. And so you then go and purchase a property, but you should undo it as well. And so the adage really is that if you are a trustee, you should not purchase trust property. Just keep yourself clear, don't purchase it at all. Name the ways in which trustees can be removed from a trust. How could they be removed from a trust?
Retirement.
Through retirement,
Okay.
through death,
It could
The
remove
court.
the
the
beneficiary.
court could remove them, the beneficiaries could go to court and have them removed,
Or the trust instrument must.
or the
stay.
trust instrument could indicate that, if they want to retire, these are certain things that they have to do. They have to give 30 days notice that they wish to retire as trustees of the trust.
Can the power hold on to the moment?
Depending on whether or not he has that power under the instrument. For instance, the protector may have the power under the deed to remove and appoint trustees. And that, for the protector, that is one of those normal kinds of power that he has. And so if, for instance, you followed with your protector, and let's say your fees from that trust is something like $500,000 a year, you can bet assured that you're going to lose the trust and you're going to lose the fees. And so the removal is done by the protector. It could be done by the settler if he reserves the right under the instrument to do that. And so there are several ways. If he dies, he has to be will be able to excuse his trustee. He goes to court and asks to be removed. He can be done, it can be done that way. Now, there is a case, Lettestead versus, what was it, 1884, talks about the court and its jurisdiction to remove the trustee and to appoint new ones. If a trustee seeks the consent of the court to be discharged from his responsibilities as a trustee, who pays the cost? The trustee. Yeah, because he has that desire. He wants to be removed. He goes to court, and so he must pay the court fees or anything associated with it to be removed. A court may also remove a trustee from a trust where there is found to be a continuing conflict between the trustees and the beneficiaries. I think he said that was true. I had a case which had some property in Eleuthera. You had the settler who was into his second marriage. From his first marriage, he had 5 children, and then he married another wife. And so they had properties in Eleuthera where he lived. There's a main house on the beach, and there's tennis court and all that sort of good stuff. And he happened to die. But he set up the trust so that the wife on his death received half of the value of the trust or whatever, and then was entitled to the income and so on, but excluded the children. And
So he included his first and second wife?
no, the first wife was out of the picture. I think she died or something like that. But he included the second wife.
Only, huh?
And so, yes, and so the children, I think, out of the trust, they got some, they were entitled to some like $2,500 each out of the trust. And the stepwife had all the other things. And so, and then there was some contingent beneficiaries. And so, that's terrible.
I mean, well,
Yeah, well, the
I guess that's a lot of
rationale behind it was that he had indicated that the children really did nothing for themselves, and they depended on him to feed and clothe them, although they were off age, and that sort of thing. And so he just gave them a small thing. And so they didn't like the stepmother. No one likes stepmothers, from what I could gather. No one likes stepmothers. And so we had to go and take an inventory of all the properties and to see the buildings and so on. And every time you wrote down something, they say, oh, that belonged to me. This belonged to me. And
Because the children's at home.
the children under the stepmother, then she said, she brought a list of things from Canada and she came back out of the Bahamas. I was one thing after the other. But the state had no money. And in order to satisfy whatever needed to be satisfied, you had to sell the property. And so we put the property up for sale. And every time we got a buyer, the children always say they had a better deal, and that's why. So there was conflict between the stepmother, the trustees, and so on. I think eventually we just asked to be relieved as trustees. And so
So how they they just have to fight over it.
Well, no, they just have to find some new trustees. The court will remove the trustee, but they will then appoint new
I
trustees.
have a question. In that case, that's a fixed trust, right?
Mhm.
And so, why is it that, I guess we were talking about, so they were beneficiaries of small portions, but the wife was the main beneficiary?
Mhm.
So why was,
Like, what's the big deal?
Listen,
Say it was.
why?
Yeah, but the problem-
Why should someone say to keep
No,
looking
but you
at
see,
it?
the problem is the trust had no money.
Yeah, but
Oh,
obviously
so
the
they
wife was
couldn't
okay
get
And
with
so
it.
in order for them to get
So
their
they couldn't get their
portion,
portion.
you had to sell the trust
Right.
property.
Right, yeah, I understand.
And,
Why couldn't
you
come
know,
with
there's
somebody
certain
else?
things, for instance, the guy he had a farming exercise as well. And he had a tractor that they did use for farming. And he left the tractor to, one of his employees. And of course, then you went up, no one could find, well, we saw the tractor, but they had disassembled the tractor, and couldn't find the parts for the tractor.
The children,
Children,
Yeah, I don't know who did it. Subway did it, but they had some warehouses on the property, and I just said, where are the keys? Nobody had the keys. These things locked up. So I just got someone to open it, and in one part they had some parts of the tractor, and then they had something else and something else and something else, you know. And so,
it's so disgusting.
That's why he didn't
it,
do nothing.
you know, the thing is,
It should be probably
you-
just zero.
you know, you have these sort of experiences, you know, as trust officers, what do you do?
That's how they-
And you just have to follow the book.
But then if it was fixed, then you know, couldn't just say, well, there's nothing we can do. This is what your dad said we got to get 2,500.
But that's all they would get, and they knew that.
So
That's
they
them,
They-
but I couldn't come up with that.
They just wanted to make sure that
the
they give that
Yeah.
stepmother all kind of trouble.
Yeah.
the longer they
Mhm.
could stop her from getting
Yeah,
hurt,
because
it
you
didn't
see,
matter if they were
for
getting
instance, we
hit.
had to do an inventory on the house.
Absolutely.
The main house was on the beach, that's where she lived. And so, we had to go to do an
So the children
inventory
didn't
of the
obey.
house. And everybody else wanted to come to see what was in the house. Obviously, she wasn't letting them in the house.
Why would she though?
And, you know, so it was one thing after
They
the
probably
other.
should have set up something separate for them from Snowball. I thought that was true.
You should probably just save up $25 each.
Just leave them.
Yeah. No, it was one of those very interesting cases that just drag on forever and ever. And then in the meantime, the properties were going into disrepair.
That's just because
You know.
basically.
So, and you just have to be careful, but, and that's one reason as to why you could always ask to be removed. And where there's conflict between the beneficiaries and the trustees in particular, the best thing is to get out of the arrangement.
So when the court appoints new trustees, can they refuse or they'll have to?
Well, they will have to agree among themselves as to whether or not the new trustees are acceptable to
Would
them.
they be, I mean, would the courts be open with them and tell them, this is a problem? situation?
Yeah, the courts will make the final determination, especially if you put all the facts to them.
No, what I'm saying, the
And-
courts would be, for the
Honest.
trustees, would they be honest and say, look, this is a problem, trust?
They don't say problem, but
I don't
I'm not
think
saying like
so.
that, but.
I don't think so, because all the courts want to do is make sure that an appointment takes
They're
place.
just trying to get-
Yeah. Mhm.
Why are they here for?
But my question
We'll
though
be
is,
back
can the
in
new
next couple months.
trustees refuse?
Acting as trustee for those beneficiaries, or
If you appoint a trustee, you have to be trustee for the whole trust. I mean, the beneficiaries are
Yeah,
just
that's right.
incidental, they're the enforcers of the trust, and so you have to either decide you can live with them or not live with them. And if you have heard the story, if you believe the you won't be able to function, you won't accept even if the court will invite you to
They can't
become
force you to be
they
a
can't
trustee.
force you to take on the trust. They'll have to invite you to take on trust. And the recommendation for the new trustee will come from the beneficiaries concerned, agreeing together. I mean, now, they might agree once they get the new trustee, but then they go back to the same old ways with the conflict.
So do you know, I mean, I know you said y'all were not
Mhm.
trustees anymore, do you know if that was ever settled?
I have
Or
no
they still
idea.
fighting?
She
But
probably
is
just give them a property to share.
Mhm.
No, they want
No.
lots.
Not what is ours.
Is it, when they appoint trustees by the court,
Mhm.
is it within the same company, or can they choose a different company?
They choose a different company. Yeah, because you see, you have to understand that if you work for, let's say, J.P. Morgan, which is a trust company, or you work for CIBC Trust, which is a trust company, the appointment of trustee is the company, all right? The persons who administer the trust on behalf of the trustee are the employees, who are the the trust officer or administrators. And so they're not appointing you as an individual, they're appointing the trust company as a trustee.
Okay, so you don't yourself make the decision to remove yourself from the trust, the company.
Yeah, the
You would have to
company-
take it to the,
Yeah, the board of directors
Board,
will decide what to do, because they will all act in concert with each other in making decisions and so on. You, as a trust officer, you might be administering the trust. You might be paying out income or capital and using your, doing the discretionary things. But normally, those things are collective responsibility of the trust company. And so, although you're the administrator paying out the income, you're doing it on behalf of the trustee, who are trustees of the trust. But of course, now you have to realize too that in the Bahamas, there are certain things, penalties that arise if, for instance, it is led to believe that the trust is being used for money laundering or drug trafficking, and as a trust officer, you have knowledge of that, and you don't disclose it. You will then be put before the courts in your personal capacity. Okay?
so you break off from the company then.
What company
They
break off?
leave you on your own, you said you go to jail by yourself.
As a trustee,
Mhm.
as a trustee, saying that this, I know a trust is something that is public or
Mhm.
for public review.
Mhm.
Anybody that can go and audit or review, especially with the courts have certain auditors that come and oversee your work or something.
No,
I mean, somebody
unless-
will know if you.
Unless something goes wrong in the trust, the beneficiaries decide that they're going to take the trustees to court, that is when the courts will get involved.
I just know that if there's some kind of.
Because if the trust is running smoothly, there's no need to involve the courts. But if the beneficiaries feel that you're not administering the trust as the way you should do it, you're doing a poor job on the investment side, you're not paying them or some administrative thing, then they can take you to court. That's when the court gets involved.
So I'm thinking if you, if the beneficiaries or they or whoever uses the trust as a drug trafficking, they would want to report if something goes wrong.
I don't think so, but I mean, you know,
Because you
It
don't
will
want to
happen.
find them out.
well, that's true. You see, the trust is one of these peculiar things where, first of all, it's not registered anywhere. It's an arrangement between the trustees and the settler. The vehicle which they will probably use as an underlying company that will hold all the assets and the company is an individual in law, and the company is registered, and so you can bring an action against the company, or the company can bring an action against anybody else. And so, anytime you hear them talk about money laundering, it's always in a vehicle that is not the main vehicle. Because you will find that in trust, they don't have bank accounts. You know, because, you know, if you then open an account, let's say a Commonwealth Bank, in the name of the trustees, you know, for an individual, they tell you you have to bring everything, including the wash tub and the thing and the thing, so that they can know who you are. So you can well imagine if you had, say, you're going to open a bank account in the name of the trustee of the trust. You then do a disclosure of all of your
Yeah.
beneficiaries,
Yeah,
which
okay.
is not the intent of a trust. Okay? And so the trust will wholly own a company that will then be able to open a bank account with Commonwealth Bank, depending on their stipulation and so on. And in that case, it's the directors and officers of the company acting on behalf of the company.
I have a question in relation to the lady
In what?
with the children
Mm-hmm.
and the lady.
Mm-hmm.
How, if the trust had no money, they
Mhm.
only had the asset, the house and
Yeah,
everything,
yeah.
how were you remunerated?
Well, you know, that was one of those amazing things. You couldn't get your money until you get some assets. So.
So that's why we didn't put on that list, you know? It's costing us too much.
Yeah.
Discuss the journey and let me sell this property, let's just call this
Yeah.
hands wash us.
No, it's just
Yeah, but-
sometimes you just have to make those decisions.
Okay, so you
Um,
just walk away from,
You just, and you could the thing is, and the other alternative is to go to court and have the court say, you know, you can get your fees by selling so and so
Okay.
and so and so to
but
satisfy
they will
your
still
fees.
remove you?
Yeah.
Okay.
Um,
Yeah. I have been
Gone and
You
you,
know, we'll
these
get that money, yeah.
miserable children.
What is the role and responsibilities of the trust administrator?
Carry out administration of the trust with the guidance of the trustee.
And you have a whole unit on that, you know. And,
But we have some, like,
Yeah,
we
yeah.
jot it down, but let's.
To be familiar with the trust,
Mhm.
to manage the assets placed in the trust, familiarize themselves with the beneficiaries, accounting and reporting, review
So
the
the overall
information of
administration.
trustees, take minutes, record keeping, notices and consents.
So you made some notes.
Mhm.
Yeah. Anyway, that might be one of your short answer questions, eh? And so, be familiar with that, because you cannot be a trust administrator or trust officer unless there's certain things that you do. And one of the most important things is to become familiar, first of all, with the trust document, and then the law that governs the document. And then, of course, the needs of the beneficiaries, the wishes of the settler, and those wonderful things. Make sure you take a review of the documents, make sure that things are done on an annual basis. If, for instance, somebody has died and they're one of the beneficiaries under the trust, it may cause some other things to happen. Make sure you have, your documents will include things like birth certificates, marriage certificates, and death certificates as they relate to the beneficiaries of the trust. Because you have to remember that some trusts will say that they've created a trust for the children of the marriage, or children, grandchildren remote issue, not named but you have to establish that family tree, eh? And I think sometimes that's the difficult part, because the parents or the settler may not provide the information altogether. And then you have to make sure too that you have the documents, because if you're paying income and capital to somebody, you got to make sure you're paying the right person. If you pay the wrong person, cloning your money, you have problems. You just have a total problem, because whenever you pay somebody, you're not going to get the money back just like that. And so, and especially if you're doing a will, make sure that the person named in the will is the person. We had a case where a lady on the Eastern Road made a will. The company became the executors of the will, and in the will, she said that she left some money for the two boys who brought her newspaper to her on a daily basis.
How y'all find
Ain't no
out?
one know who they were.
How y'all find out?
How y'all find
And so you had to find on Eastern Road. Obviously, if they delivered newspapers to her, they delivered to somebody else. And so we're able to determine who else in that community they delivered newspaper to, and finally we're able to contact someone. There's always someone will know who they are, and able to contact them, and they came in, and by that time they were men, you know, but because she said that, you have to do it. And I forget how much it was, she left each of them, and you had to pay them the money. And of course, it wasn't much money, you know, I mean, that's something like $500 or something like that. But whatever it was, you know. And she was just, she remembered the newspaper boys. And of course, Ben Bonham came in. I knew the person. I said, I know you sell newspaper. And then, of course, if you like that, they tell you the story. And so you were able to identify. No name, but just newspaper boys. And so sometimes trust officers have to use their imagination in order to complete the things that they need to do. Section 83 of the Trustee Act 1998 allows beneficiaries to review and receive which documents? You all know Section 83, right?
Yes.
Okay.
Accounts of the trust.
So the
Any thing that the beneficiaries are saying.
Yeah.
Anything that relates
anything
directly
relates to the
them.
trust, yeah.
Section 83 of the Trustee Act 1998 allows beneficiaries to review and receive which documents? Trustee is one, yeah, the accounts, yeah.
The other documents except the trust minutes.
Except trust minutes, that's the exception. And please remember too that when you talk about accounts, they can only receive the accounts that relate to them. And so you're able to edit the documents, and that's one of the things the Trustee Act allows you to do. The trustee's duty is to account for trust property, state ways in which this is done.
Sorry.
The trustee's duty is to account for trust property, state ways in which this is done.
And they're, I guess, related to like a report.
Yeah, there's reporting, there's accounting, You did you had a session on general principle of trust accounting, right? Did you do any examples like on the board and things like that? You did?
Like an income statement,
You did an income statement, you did?
the balance sheet.
Okay, because I noticed in the notes, I mean, they just have verbiage.
Then you don't know accounting, like it's
So
studying my
basically, yeah.
area.
So what?
The balance.
You have a
Listen,
little balance sheet.
let me tell you, if you're a trust officer, you will find the trust officers do more work than an accountant. They do more work than a banker. They do more work than investment advisors because they have to be knowledgeable of everything. And that's why they get paid so good. Oh, okay. I need to go back asking for my money. No, that's true. That's why they paid well, right? Because apart from that, by the mere fact that you are reading a trustee, you are also acting as an attorney. And so
So
you have a whole lot of discipline, huh?
You have to have background in law and because that legal jargon.
You know, after a while, I mean, well, this is just part of your trust thing, but they have extensive courses in trust where,
Because I have trouble reading this act right now.
yeah, okay, no problem. No, I mean,
I mean, I read it, but I sometimes
it don't stick. Yeah. No, because I think the more you read over and over, it's a sort of repetition kind of thing. Then you'll be able to understand it. When I did my qualifications, you had to do things like taxation, and that's long before that. You had to do law of persons. You had to do land law. You had to do things like accounting, trust accounting, and a whole series of things that you had to do. And so eventually you find that a lot of trust officers could just go and study law because they become specialists in those areas. I have a daughter who is a lawyer, and then she worked with Higgs and Johnson. Anytime I could always tell when somebody asks her something, she called me to ask me. I said, this is a trust matter. I said, but you all have all the attorneys there. She said, no, but daddy, so and so and so and so. And I know somebody in the firm would ask me. I mean, I used to get calls from some lawyers. They say, oh, do you have so and so and so and so? That's when I was working in trust company. And so, you know, the trust officer really, he has to know banking, he has to know law, he has to do bookkeeping, he has to be able to do investment management and those sort of things. And becomes a well-rounded individual. And like she says, that's why they get paid a lot of money. I'm still waiting for money.
It was such a,
Huh? Yeah.
have some handsome songs.
Name 4 important considerations which are to be made in relation to the income from trust property.
The power of the trustee to accumulate or retain income, the extent to which income may be paid or used for the benefit of special beneficiaries of specific needs, example, physically or mentally challenged beneficiaries, the beneficial interest which may be entitled to income, the proper accounting of gross income and extent to which this income may be distributed to the relevant beneficiary.
Yes, those are some of the consideration. Now, you'll find that all of those are in your trust deed somewhere. The trustees will have a power to either distribute income or to accumulate income. And so it gives you that ability. The payment of income and capital to beneficiaries are done in accordance with which document? The trust deed, yes, simple answer, trust deed. And in your trust deed, if you're gonna pay income away, you go and see which clause you have to use to say that you're paying the income under that clause, and if you're gonna pay capital away, under which particular clause. Because in your trust accounting, you have to account for all the income that is received, any income paid out, any capital that is received, and any capital distributions that are made. As an administrator of a trust, how will you use the information contained in the settlor's letter of wishes?
As a discretion.
Yeah, use it as a guide. You don't be a slave to it. You just use it as a guide, because the settler will come and sit down with you, and he will tell you, he might express his wishes, or he might send you a memo to say, this is my memorandum, this is my wish list, like when we all do for Christmas. You want a new dress, you want new shoes, you want this, and then you want an engagement ring and that kind of thing, you know what I mean? The wish list.
Or you never wish. Just guidance.
Just guidance.
Yeah, just for guidance purposes. And so, the fact that he's put it in the letter of wishes, he may say, on a quarterly or on a monthly basis, income should be paid to so-and-so. Or on marriage, I would like you to pay X amount of capital to my daughter Jane, something of that nature. And so you know that as a trust officer, if the person gets married, there's some provision that you can exercise your discretion because you've been triggered by the letter of wishes. Or if the person goes to college and you have to pay college fees, the settler will say for their education and their maintenance. And so as long as they're in college, so long as they're doing that in college, you pay the fees.
That's well beyond the letter of wishes.
No, sometimes it's in the deed itself. It will talk about the education and maintenance of things. And so, if a school bill is represented, a college bill is presented to the trustees, you know then that the child has gone to college. The settler will either indicate that to you, or the protector will indicate the child has gone to college, and which college. And when you get the FINO from the college, you pay directly to the college. You don't pay to the individual.
I want to see if I could understand, based on that example, like something like that, perpetuity. Okay, okay. I think that, okay, the trust, so for example, the trustee can have a clause in it where we say, well, I would like my son, Adam, to obtain his his law degree within the next 6 years, and he can say if he has not obtained it, he won't receive a certain gift. Is that the part that is abolished? I hope.
Well, the law against perpetuity is talking about the life of the trust. It talks about how long the trust can last. And then if a gift isn't vested in a certain time, it falls away.
So it could be anything, like it could be a diamond, like
Yeah, it could be anything. as I said last week, like if you're dealing with a will, for instance, and the settler, the testator says to you, or he says to the executor, I leave a diamond ring for Sue. But when he comes to look at the assets, there is no diamond ring. He goes and purchases a diamond ring. But if this testator says, I leave my diamond ring to Sue, and there's no diamond ring, that gift fails. The emphasis being on my diamond ring, which means that the settler owns a diamond ring somewhere. And so if when you come to look at the assets and you find that nobody could find this diamond ring and there's no diamond ring, the gift fails. But if he says, to Sue I leave a diamond ring, if there's no diamond ring at the time of gathering the assets together, you then go and purchase the diamond ring. So the word that makes the distinction is the my Rolls Royce, my yacht. Now if he says I to the exact a yacht for so exactly that I must go and get a yacht. Okay? And so the law against perpetuity, I think for your purposes, just try to remember that in essence it says that a trust must come to an end in a specific period of time. Okay? And
The part that is abolished, that's where what part of it is abolished, that something that's not received in a certain time? That's something.
yeah, where's it in your notes? Find it for me.
I
So
just,
we're page it on.
no, I remember it, but I just can't remember it.
That's in section unit 4,
Sorry?
unit 4, page 28.
Oh, I was way up.
What page is it?
28, unit 4.
Oh, right at the very
Page
beginning.
28, yeah, page
28.
Our page
Our page
28.
28, so unit 4.
Yeah.
Your
page.
page 28. What's the heading?
Unit 4.
Unit 4. Fidelity of trust.
Right, 3 pages in. Rule against perpetuities.
Rule against perpetuity. The rule against perpetuity states that the grant of a contingent interest is void at the moment it takes effect of common law, unless it is certain that the interest will vest, if it vests at all, within the perpetuity period, which consists generally of a life or lives in being, i.e., lifetime of persons alive at the date that the gift comes into effect, when the grant takes effect, plus 21 years. So, the gift, whatever gift it is, has to be able to vest within the perpetuity period. It has to vest during the period of which the trust is in existence, if it vests at all. And so, if let me see, I don't even know how to give you an example of something like that, but it's a contingent interest, which means you have contingent beneficiaries who may not benefit at all. It's a contingent interest that may not happen. It's something that may not happen, and it's void at the moment it takes effect at common law unless the interest will vest. It has to be an interest that will vest in somebody during that time the trust is alive. Okay? And then it says here, the perpetuity period which consists generally of a life or lives in being, i.e. the life of a person alive at the date of the gift is made, comes into effect, then the grant takes effect plus 21 years. And so in a lot of your trustees, you find that they talk about the life and being King George V. And so you go to that date and you see who's alive at that date, and that's the life and being. Or the settler may say during his lifetime or something, words to that effect. But the gift has to vest within that period, and so if it doesn't vest, it doesn't have the possibility of investing its void. It is all to do with a gift of a contingent interest, right?
I think I get that.
You get it now? I think so. The property must vest in the recipient of the gift within the perpetuity period, and the property must not be limited and rendered inalienable. In other words, the property can't be out there, and you can't touch it, you can't feel it, you can't get to it. That's the whole thing. You can't alienate the property. Alternative court may say wait and see whether the gift will be void by salvaging portion of the gift that does not offend its rule against perpetuity. Court will say wait and see, which means there is a possibility that the gift will vest. It's not that it will vest at all, but it will vest. And so just look for that possibility. A gift to charity is exempted from the rule if the prior interest is also given to the charity. So, and that you have charitable things, because charities go on forever. Yeah. I know, but none of them collapse, but charities go on forever. And so, no matter how long the period, charity will be around and charity will be again. Okay. But just read that over a couple of times and try to, I think the whole matter of whether or not it will vest is, I think that's the difficulty you're having. Right. Oh yeah. If you are requested to make an income payment from trust funds and there is insufficient income, are you able to pay the same from capital?
No, I think it should be, it should get
Sell
separate.
it.
It's separate, yeah, and your accounting income is separate, capital is separate. And if you are asked to make an income payment and there's insufficient income, you can't fulfill the request. You can't take it from capital unless it says specifically you can take it from capital. As an administrator, are you able to pay expenses from capital income? And if so, what are your reasons for doing so?
I mean, from capital,
Are you able to pay expenses from income and capital? And then you're able to apportion between the two. It depends. So you gotta remember too that your expenses for accounting purposes could be divided between income and capital depending on the nature of the things. Let's say if you were doing insurance payment, for instance, you may want to apportion it between the two. Define advancement.
any
Good.
large payment or distribution of capital.
Sure.
Any large payment or distribution of capital to make some long-term lasting provision for a beneficiary of the trust.
Yeah. Advancement, their maintenance advancement, they're making long-term capital payment. And sometimes, of course, if you do an advancement to a beneficiary, when the trust is coming to an end or when the trust is being distributed, you have to bring them back into account and do distribution that way. Define appropriation.
Trustees are for specific
Hmm?
purpose.
Sorry?
It is the trustee's action in apportioning part of the trust assets for a specific purpose.
Yeah. An apportionment of any of the trust assets. Which section of the trustee act gives trustees power to invest?
Section 30.
Who? Yeah, okay. Which section of the trustee act gives trustees powers of investment?
This thing, power investments.
The power to
Is this
invest.
4? I think section 4. Section 4.
Section 4,
Section
yes.
4.
Oh, you hold the paper off there. Yes, it's section 4. And you have to remember that if there's an absence of a power of investment in the trustee, you take advantage of the trustee act. Okay? What are the rights of the beneficiaries? Who? Yeah, rights, yeah, okay, that's first thing.
They have the right to review any documents in regards to themselves,
Mhm.
to review the common trust.
Yeah, anything to do with documentation, they have a right to information, as the access, they have a right for information, but information that relates to themselves, okay? Name the types of breach of trust. What are some of the types of breach of trust? That's in the last section, right?
Wrongful distribution of income. Incorrect exercise of the trustee's discretion, not distributing income or capital as required by the terms of the trust, improperly selected and supervising agents, misappropriation of trust funds for a trustee's personal expenses and benefit, failure to obtain the relevant consent as required by the trust instrument, purchasing trust property without authorization from the trust and or beneficiaries, unlawfully profiting from the trust, investing trust funds in unauthorized or unsuitable investments, and failing to accompany beneficiaries.
You can remember all of that.
The words of God. God's words.
Okay, what remedies are available to beneficiaries for breach of trust? Injunction?
Action against the trustee for loss.
Mhm.
What is that?
Huh? What's an injunction?
Stop.
Injunction? Stop, your stop and review, cease and desist. No, an injunction is what happens, the court will issue an injunction. If, for instance, the beneficiaries feel that you're doing certain things and they want you to stop doing those things, they go to court and they ask the court for an injunction. And the court will issue an injunction. That means that you cannot do what you were doing. Okay? Yeah, an action against the trustee for loss suffered a proprietary remedy to recover trust property. In other words, if they've sold trust property, the remedy is to get back the trust property. Yeah? An action against those who have received trust property. And so, let's say, for instance, the trustee has gone in collusion with one of the beneficiaries to purchase trust property, but purchase it for the beneficiary concerned. And then you can take an action against that person to recover the trust property. Explain the term arbitration.
Arbitration is where the two parties come together in front of, I guess, an independent party without going to court, and a decision is made by that third party.
There are some people now that are qualifying as arbitrators, and so instead of going to court, you can have a thing of arbitration and come to a sensible conclusion on matters. Section 23 of the Trustee Act provides for what?
Devolution
Devolution
of
of
powers
powers
of
of
trustees.
The what?
Devolution of powers
Powers
of
of
trustees.
trustees, yes. You sure? Okay. Right, and that is, what time we're on? Any questions, any difficulties you've had with the whole, the court?
Just the same.
Hmm? Not anymore? So everybody will pass the exam.
I didn't say all of that.
Hmm?
I am bound.
Didn't say all of that.
So we have to actually know notice or just know
Sorry?
what is located
See, see how he randomly said what section is to invest? The power to invest?
Yeah, I didn't know that.
We have to randomly know what section.
That's what I'm saying. I could know, like I could learn, but study all of the sections. And I'm gonna study.
What is
Section
in the section?
53 A, B, and the third level.
No, but,
whatever. But it's the next.
I think in the reading of your material, there are certain sections that have come up in more than one unit. For instance, section
Section
83 has come up,
Yeah.
okay? And so that should say to you, if section 83 has come up,
Disclosure.
let me understand what section 83 is all about. If section 4 has come up, let me understand what it's all about.
I never even heard of this.
You have no idea how many
I've
pages
yeah,
this
I've
is
never
in.
heard of the power, the devolution of power
What's
Mhm.
that about? Is that-
of trustees. I guess we'll have to read the trustee
The
section.
trustees, section,
23.
yeah.
Because it's page 25.
Before y'all do this, it's a short section.
No, I thought it was like a.
Devolution means getting rid of. I mean, you
Okay.
get rid of certain things, yeah.
So we have to look at this too.
What's that?
Official Gazette, promise. I don't know what it says. I just read this.
What is it?
Amendment, is it? Oh, never mind. Yes, we have to look at this.
An amendment,
Well,
yeah.
the only amendment we looked at was in accordance with arbitration
Mm-hmm,
with the second schedule, section 91.
yeah, because that's new. Mm-hmm.
What do you know? I just turned to that same page. It's probably gonna be on the test.
And decide, do you, no other questions for me?
You don't know how many
Do we
pages
have class
this
next
will be.
week?
Pardon?
Do we have class next week?
I was supposed to have, and that's what I couldn't clear up with Miss Dana knows, because I know I missed a class,
But we had the class.
and you had a class, so, I'm
So
taking
I
that,
guess this is the last.
that is the last class.
Come on, when they
No,
exam?
2 weeks to study.
The 23rd. Y'all said it's 6 now, right?
Yes,
Yeah.
6 o'clock.
6 p.m.
23rd doesn't leave after after next week.
Two weeks.
Yeah, stop saying that.
In 2 weeks.
Go on, yeah,
She
man.
making it sound so early.
It's early.
My nerves on me already.
You better get it on
This
now.
exam was in
Yeah,
June,
I
it still
know
would have
that.
been too early.
Alright.
No, I want our family.
I want her to get this exam. So I can move this next.
I want her to get it over with. Because I'm not ready.
I'm ready, I don't guess what.
When I am ready, I will.
Ready.
I will be ready.
I never even stopped
You
when
still
it's
have time.
Okay.
Yeah,
That's why I want this exam to be finished, because I'm tired.
Yeah, you still have a
Yeah, but you
Yeah,
get a break.
Y'all go through it.
When I can be sleeping.
And that's not a good one.
Isn't that September?
The better thing though, if you've completed stage, this part one, administration one, and you get through it, you may as well go straight into
Right.
administration two.
Now, if I
Because if you
fail,
take a break,
Yeah, makes
Then you
sense.
can
yeah,
lose all
yeah,
the information.
yeah.
That's like,
I have leave to take her out.
ah, this is wet. I'm getting kind of old here.
Big chicken rolls.
chicken,
Chicken. Jerk chicken.
chicken.
We got the chicken?
I don't think cutting was in my jerk.
What's that?
Still have no sauce on it.
No, see, y'all understand. Jerk.
Just read it.
There's the jerk with the sauce on it.
I like
yeah.
when, I like bamboo.
Yeah. Like imitation jerk.
No,
When you say it's a jerk, see, that's what it is. Jerk does look like- mine hers are the same. Y'all don't know what none of them. It ain't saucy, but it has the seasoning on it.
Seasoning on it.
Yeah.
It's almost crusty.
Anyway, guys, y'all drive
And then
safe.
it's herb crusted chicken. I'll see y'all on the
Study, I don't know how this is gonna go for me. See y'all on the 23rd.
Boy, I hope I remember. Don't forget me tomorrow, please.
For the Williamson. Ready, sir?